Okay, my elegant warriors, I'm so excited to introduce you to today's guest. His name is Shanin Specter. He is a founding partner of Kline Specter, which is one of the, if not the, preeminent law firms in the nation. He teaches at the University of Pennsylvania, Stanford, Berkeley, and Hastings law schools. And today we're going to talk specifically about one of the classes he teaches, which is called How to Ask a Question. He is also my friend. Welcome, Shanin Specter.
Heather, great to be with you.
It's so good to have you here. And this class, How to Ask a Question, is intriguing not just to me, but I know to people at your schools who aren't even law students. So first tell us, what made you want to teach a class called How to Ask a Question?
Well, I had taught trial advocacy for many years at Penn, and it occurred to me that there were a lot of law students who didn't want to take part in the mock trial part of the class because they just didn't feel that they had it in them to get up and give an opening speech or to do a cross-examination, but they wanted to learn the skills of question asking. So anybody who teaches trial ad knows that, yes, the trial part is an important part of the class, but so are the skills learning aspects of the class. So I decided to take essentially chronologically the first half of the class and teach that, and then just not do the trial.
Right.
So that's what I've been doing now for about 10 years. And I've done it at all the law schools you mentioned, plus also Drexel Kline. And you alluded to this a moment ago. I've had students come over from other colleges in the university, especially the business school,
Yeah.
to take the class because they want to learn about question asking. And of course, many law students are taking the class now who have no interest in being a trial lawyer, but who just want to understand issues around how to ask a question.
Yeah, it's a skill that we're not taught in school until now, and not everyone can access. And that's why I wanted to bring you in, because my listeners there are some lawyers, but they come from all different professions, all different walks of life, and everyone can use questions to sort of get what they want. I wonder whether the first thing that one needs to know is why they're asking the question in order to know how to ask the question. Do you find that to be true?
Well, I think that is very deep, and I don't want to start in such a deep way because I think, at least for me, in teaching the skill, I need to start someplace more simple. So may I tell you how I start the first class?
I love it.
Here's what I say. I say, you are caffeine intolerant, and you go into Starbucks and you order a decaf grande and you pay for it, and then you walk over to the portion of the coffee shop where they give you your coffee, and of course someone else serves you the cup versus the person to whom you made the order, and remembering that you are caffeine intolerant, what do you say to the person who hands you the coffee cup so that you don't end up waking up at 2 o'clock in the morning because you got the wrong thing? What do you say? That's what I say to my class. And I say, what do you think? And then I'll get hands, of course, and people will often say, is this decaf? That's the question. And I say, no, that's not the question. I say, because, and this goes to your question, which is the why of it. You have to think about the circumstance. The server is busy, and she may care a little more about getting through her day than she does about getting to do the right thing.
Yeah.
So she may simply agree with whatever you say. If you say, is this decaf? That's a leading question. It leads to the answer, the easiest answer of yes. So a better question would be, is this regular or decaf? Makes the person choose. And I'd rather lead with the answer that would be a problem for me, which would be rare, because people will sometimes choose, if they don't know, the first thing that they have been suggested to, in this case, regular. And of course, if I hear regular, that means she doesn't know what it is she poured, or she poured the wrong thing, and therefore we have to start over again.
Yeah.
Or I might say, what kind of coffee is this?
Yeah.
That's entirely open-ended. And it doesn't mean for sure that you're going to get decaf at the end of the day, but you're raising your chances considerably that you're going to get decaf.
Absolutely. And it sort of gets to the why, right? The reason I'm asking this question is to ensure that I'm not up at 2 a.m. I think the reason that I started with that question is, for me as a trial attorney, I enjoyed cross-examination more than direct examination, but there are very different reasons for it. Sometimes you ask questions to build connections with the jury or to allow the jury to discover more information. And sometimes you ask questions to prove something wrong or to embarrass someone or to make someone look bad. And I think outside of the courtroom, for everyone listening and everyone in your class, they ask questions for different reasons. When you are looking to make connections with questions, is there a certain way that you suggest that someone does that?
Well, let's remember that as a trial lawyer, I am an advocate. So I am looking to win my client's case.
Right.
And every question that I might ask is done not really to make particularly a connection, but rather to elicit information that's helpful, and particularly elicit it in a way that is helpful. So one thing you were probably taught in law school, because this is what almost everybody's taught in law school in trial act classes and the like, is that you should ask leading questions on cross-examination. And I understand why that's said, because it provides more control. If you're asking leading questions that are yes/no questions, you can control the pace of the conversation a lot more easily. But a problem is that sometimes the jury may think that the answers are the product of the questioner and not the product of the person who's answering. And that could undermine the credibility of the answers and therefore not be optimal in terms of proving your case. So one thing that I teach my students is, to the degree that you can, try to ask your questions on cross-examination in a non-leading way.
Yeah. So
that the jury feels that the answer that they're getting is a true answer and it's not being forced by the questioner. And along the same lines, of course, your listeners may be saying to themselves, well, isn't that dangerous? Because if it's cross-examination, it's an adverse witness, and if you ask a question in a non-leading way, they may give you an answer that harms your case. Well, no, because, of course, as you know, Heather, because you're a very experienced and excellent trial attorney, and I know that from personal experience. I have scars on my back still.
Oh,
but we don't ask questions, do we, on cross-examination that can hurt us. So if it is an important question about the case and not just a warm-up question, and we ask it in a non-leading way, and they give an answer that is very unhelpful, we presumably have some impeachment material in front of us, a prior statement that they made or the like, which we can then present to them and cause them either to correct their answer or to look bad, because they've now changed their position as to what the facts are. So I'm not concerned about asking the question in a non-leading way, because if they give me the quote bad answer unquote, I can get it corrected very, very quickly.
Yeah.
But I think that we need to be mindful of the jury not feeling that we as the lawyer are seeking to overly dominate the circumstance. When you say, Heather, that you prefer cross-examination, almost every lawyer prefers cross-examination because they're in control.
Yes.
Most lawyers most experienced lawyers are more apprehensive about direct examination because they may not lead their witness, and particularly because almost always we are calling either our client or we're calling an expert witness or an employee of our client, and we know that really nothing particularly good can happen during the examination. All that can happen is bad, where the witness veers off and says something we didn't anticipate, and then we can't lead them back to what we know to be the correct answer because the rules don't permit it, and our opponent will object, and the judge will come down on us, and we'll look bad in front of the jury. So we have this terrible problem, don't we, Heather, that when the witnesses start to go down the tubes on direct examination, it's really hard to rescue them.
It is. And I've heard you talk about this on another podcast when I was doing research for this. It's hard to maintain your facial expression as impassive and as if this was exactly what you expected when things come out of people's mouths that you don't expect. Talk to us a little bit about that. How do you handle when a witness goes down the tubes as you're in the midst of questioning or on cross-examination?
Well, on direct, it's really tough. And if the witness is there to establish an element of your claim or defense, you're going to have to gently lead them back to establish those claims or defenses. Because otherwise, if you're plaintiff's counsel, you're going to end up having a case dismissed at the conclusion of your evidence. It's called a non-suit. It's every plaintiff's lawyer's nightmare. If you're defense counsel, your affirmative defense will be dismissed at the end of your case. So you can't let that happen. And even if you have to draw objections from your opponent, objection, Your Honor, leading, sustained. Okay, yeah, right. But now that gives a clue to the witness. Hey, you know what? Yeah, right. The light actually was green. The light wasn't red.
Right.
So now they'll say, "Oh yeah, Mr. Specter, I thought you're asking what color the light was for the other guy. No, for the light for me, the light was green." Okay. Thank you, sir. Now you're back on. So that's one way. If the witness is not an essential witness, like a family member, like a father of an injured young man, and the father goes off the deep end on direct for his own reasons, I just say I don't have any further questions. Thank you, sir, very much for coming in today. And that's the end of it. And just take them off the witness stand and just wrap it up. On cross, if things go badly, well, we aren't required to ask any questions, are we, Heather, on cross-examination? And many times we don't ask any questions for a variety of reasons. So what I think you should do in a cross-examination, essentially, is you should start strong and you should end strong. And presumably with most witnesses on a cross, you have at least two things that you know are going to work. So let's take the second strongest thing and let's start with it right out of the chute. Boom. And then let's save the strongest thing for last. If in the middle of the examination, you feel that the witness might be getting the better of you a bit, or what you're doing isn't working the way you thought, fine, wrap it up and go to that one strongest thing that you have, go there, ask that question, get that answer, and say no further questions.
Yeah. One of the things that this conversation brings to mind, it's something I heard you years ago. I heard you say for the first time, and it put me so much at ease. There's a saying in the trial law that we shouldn't ask questions that we don't know the answer to. And I never liked that saying. It didn't really make sense to me. And the way I've heard you say it, and correct me if I'm wrong, but we shouldn't ask questions that we can't handle the answer to, that we don't know. For example, as you said earlier, if someone goes, you're not asking leading questions and then they answer the question contrary to what you expected, you have that document, you have that piece of paper, so you can handle their question and play with it in such a way that you can still prove your point. Am I paraphrasing what you've said correctly?
I put it slightly differently, and the way that I put it is, don't ask a question whose answer can hurt you. So I've already talked about how if I ask a question on cross in a non-leading way and I get a bad answer, but I have what we call impeachment materials, a prior statement, I can get it corrected or make the witness look like they're not being honest.
Yeah.
But there are other questions that I'll ask, or I know that you will ask on cross-examination, to which I do not know the answer, but the answer can't hurt me. So, for example, Heather, thinking about trying a medical malpractice case, for example, which you and I have done a lot of, in Pennsylvania, we don't have a whole lot of pretrial discovery of our opponent's experts. We just get a report. That's all we get. We don't get anything beyond that. Well, we get their curriculum vitae, their resume, but that's it. So I'm sure that you have asked questions about the work that the witness may have done for the lawyer who has called him to testify, even though you don't know the answer, because you have reasoned, as I had reasoned, that as long as I do it gently, nothing too bad is going to happen to me. I may have no idea what kind of work they've done before, but as long as you step into it gingerly, it won't be a big problem. So, for example, I might say to an expert witness who's been called by my opponent, have you ever testified in court before? And I don't know the answer. And they'll say, yes. And I'll say, how many times? And they'll say, I'm not sure. Well, how many times this year, right? How many times in the last 5 years? How many cases have you looked at, right? And pretty soon we have somebody who appears to be doing a lot more work on medical legal matters than on their medical practice. And then I'll look over at the opposing lawyer and say, have you worked with her or her firm before? Okay, and then, well, about what percent of your work has been done with Ms. Hanson or with her law firm, O'Brien and Ryan? And if I have built that, he's done a tremendous amount of work that's been medical legal, and then he tells me that he's done about a third of his work for you all, it seems like he's an employee of your firm at that point, doesn't it?
That's right.
But I've gotten there incrementally. If his first answer is, this is my first case I've ever testified in, I'll say to him, welcome to the courtroom, sir. Happy to have you here. And then I'll go on to something else. Right. Nothing bad.
Right.
I haven't myself at anything.
Yeah, and you are prepared for that answer and able to move on without letting it sort of spin you and get you into a spin. Right. One of the things that I see with young associates, and I talk to people outside of the courtroom when I'm talking to them about advocating at work, is sometimes people have their list of questions and they just go down that list of questions, especially at deposition, where they have the opportunity to ask all the questions they want to ask without really listening to the answers. How important is it to go down your list versus to actually be flexible enough to play with the answers a little bit?
You have to let the answer guide what your next question is. It's a mistake to simply go down your checklist of questions. And instead, what you should do is you should listen to the answer, and invariably a witness will say something that you did not anticipate. And then you should take that statement that they made and ask all of the questions that logically arise from what they have just said. Mm-hmm. And so I think you should treat it like a tree, so that you have the main branches of the tree are your main questions. That's what you've written down on your yellow pad or on your laptop. And as you're asking these main branch questions, the answers are taking you into subsidiary branches. Well, work your way all the way up the subsidiary branch. And even when you're doing that, you'll find that the answers will be taking you to subsidiary branches. So you'll be going up now on all these tertiary lines. There's nothing wrong with that, as long as you're keeping the perspective of, I got to work my way through this, and then back down to the subsidiary question, and then back up to other tertiary branches, and then back down. And then eventually you'll find yourself back down to the main branch, which is your yellow pad or your laptop questions. And then you'll work your way to your next set. But you have to do it that way because when someone volunteers information that's beyond what you had anticipated, it's usually defensive. It's usually the product of a concern that they have. There's probably some gold there for you in your case development. So yes, that is the way to guide yourself. Now, your listeners who don't try cases may be saying, well, isn't that going to be awkward in trial when you have this sort of, it seems a little disheveled course of permitting yourself to go off on these tangents in the deposition? Well, please understand that the jury is not shown the deposition. Usually what happens is that witness is testifying at trial, and then you're going to organize your examination much more tightly. In deposition, you're trying to discover all the facts that are relevant to your case. Yep. So that's why I'm urging that you proceed in the manner I described, because I think it helps to discover all the facts, both good and bad, relative to your case in the most sensible and complete way possible. At trial, you'll be much more controlled in how you approach the questions. Even if that witness is not available for trial, you don't have to play the deposition in exactly the way that it presented at the event itself. You can simply designate the portions that you want to play, and you're going to be much more economical again about what it is you're going to have the jury see.
Yeah, it really goes to that question at deposition. The why is to indulge your curiosity, to get all of the information, whereas at trial, the why is to prove something, and there are very different reasons for asking questions. I know that we are short on time, and I want to always end up with those last three questions. Before we do, I just want to explore this. I've heard you talk about this on another podcast, on our friend Aaron Freewald's podcast. You had a very similar conversation. I'll put a link to that in the show notes because it's also a phenomenal conversation. But my mentor, John O'Brien, I once saw him on direct examination. He was examining one of our witnesses, one of our clients, and she answered the question completely contrary to what we expected. And I hope, I was young, I think I may have even still been in school. If the jury was looking at me, Shanin, they would have seen like shock and awe on my face, like, what is she saying? And John just maintained this very consistent, no facial expression whatsoever. Afterwards, I asked him about it, and he said that his butt was tight, even if his face was not. And I heard you quote another Philadelphia attorney who said something similar about responding in the courtroom and acting like everything was cool, even if it's not. Can you just tell us a little bit about how you handle the theater of trial and your body, your tone of voice, your pacing, when inside you might be freaking out?
Yes. Well, I think what John was saying to you is the expression, if you don't mind my saying this,
yes,
PG, not G. Never let your face show how hard your ass is getting kicked.
Yeah.
So John was right about that. And you must remain impassive when that happens. And I think it's a good idea to try to remain relatively impassive when something good happens, because the jury respects the professionalism of that. Tom Kline is very good at turning a good development into something funny. And he's gotten a lot of mileage out of that. So when he gets a concession out of an opposing witness, sometimes he will laugh, or he will joke or smile, or kind of needle the witness about the concession that's been made. Like, if the witness has come in from Chicago, they'll sort of end with, have a nice flight back to Chicago, sir.
Right.
Because he feels like he's gotten something from the witness. I think that's great if you can do it, but I get concerned about lawyers who try to force something out of a moment. And I think humor or anything that's not completely straight has to not be forced. If it's forced, it will appear forced, and the jury won't like it. They'll feel that you're trying to manipulate them. So my approach is to be completely straight, and I will only deviate into humor if truly I am moved by the moment.
Right.
And otherwise, I'm not going to do it. And I think I think the jury appreciates that. Another thing along the same lines that I'm asked often, I'm sure you are too, is how often do you look at the jury? And there is a an instinct that we have of looking over to see if we're getting approval, or even or the opposite of approval, disapproval, which would be important to know as well, wouldn't it? But there's an unprofessionality to doing that, because it looks as if you're trying to curry favor. And so I'll tell an associate sometimes, keep a half an eye on the jury while I'm doing this examination. I'd like to know what you think they're thinking. I'm not going to be doing it.
Yeah.
I don't want the jury to see that. I want the jury to see that I'm truly treating them as judges and not as on my team or against me or anything like that. So I think it's important that we try to maintain a bit of respectful distance from the fact finders.
Yeah, and I think it's meant to be that way. I think both you and I take it very seriously, and we're very professional. I have seen lawyers run the gamut on that, but we're not allowed to approach the jury. We're not allowed to go past the rail of their box for very specific reasons. And I don't want to go past the rail of your time. So I want to wrap up, although I could talk to you about this forever, as you know. Before I let you go though, Shanin, we always ask the same 3 questions at the end. The first question is about advocating, because I teach people how to do that. What is the last thing you advocated for, either professionally or personally?
So the last thing I've advocated for, and I'm still advocating for it, is to repeal or modify Section 230 of the Communications Decency Act of 1996, which is the provision that says that the internet service providers, which include, of course, the social media companies, are immune from suit for anything that they publish. Most people are shocked to hear that, because those immunities don't exist in our society otherwise. If the Philadelphia Inquirer or ABC Television publishes something that is defamatory, they may be held liable for that in court. But TikTok and Instagram are not legally responsible for what they publish, no matter how horrible, no matter what it is. There are very minor exceptions now in relation to child pornography, but even there, the law contains enormous loopholes. They can essentially publish anything, no matter how defamatory, obscene, scandalous, disgusting, violent, harassing, destructive, disparaging. You name it, they're allowed to do it. It's wrong. It shouldn't be permitted. And I know people say, well, how can they possibly monitor all the stuff that gets posted? And so my solution, which I've had published and I'm working on with Congress right now, is what I call notice and takedown. And that is that if you feel victimized by something that's been published about you, you can notify the provider. Let's say it's Instagram, and they have 48 hours to take it down. If you take it down within 48 hours, you can't sue them. If they don't take it down within 48 hours, then they'll be treated just like every other publisher, the Inquirer, ABC, whomever, and they'll be subject to our defamation laws, which already are very, very strict anyway. I mean, it's very tough to win a defamation case against the Inquirer or ABC anyway, but at least this will provide a way of permitting us to get things taken down that are unlawful. And those laws that I just described, notice and takedown, or some version of it, exist in many Western countries. They work just fine. It hasn't stopped people from posting. It hasn't stopped the companies from functioning there. It hasn't gotten in the way of free speech. So it would work and work well. And I think it's important to do. And I think that eventually we're going to get something like this done. I'm not in favor, by the way, of getting rid of TikTok. Right. That doesn't appeal to me, because I do think there are important things that TikTok does, and people do want TikTok, but not the things that are unlawful. The things that are unlawful need to be stopped.
Yeah, I did not realize that you were so active. I'm not surprised, but I'm glad that you're advocating for that, because I think it's really important for the law to catch up with technology in this area, and it hasn't. So we will keep an eye on that, and thank you for your work there. What book would you recommend for my listeners? I know you are a voracious reader, so I'm intrigued to hear this answer.
I knew you were going to ask me this question, and I went back through what I've been reading for a long time, and I I think that the Robert Caro series on Lyndon Johnson is maybe the best biography that's been written. There are so many great biographies, but Caro's attention to Johnson is monumental. He's been working on Johnson for 50 years. Johnson was a complicated figure, some good, some bad. I think you learn as much about the bad than you learn about the good, of course. And we're all waiting for Caro's 5th volume on Johnson. It's been in the works for over a decade. Caro's now 87. I looked this up last night in preparation for our discussion today. I think I'm getting worried about the 5th volume. At this point, Caro has worked on Johnson longer than Johnson lived the portions of his life that Caro has been writing about. But it is fantastic. And you don't have to like say, okay, 5 volumes, 4 volumes is too much. Just pick up volume 1, start it. If you don't like it, put it down. Yep. Send me a bill. I'll pay it. Isn't
he also the author of The Power Broker?
Yes, he's the author of The Power Broker about Robert Moses, which was his big break in journalism. But that happened in the early 70s when he was working on it, and it was published in the mid 70s. He's been working on Johnson since the mid 70s. So 50 years.
I just heard him on another podcast, and he sounded energetic. So hopefully he's getting through that volume 5 and we can all read it, and I will put it on my list. My last question is my favorite question. Your answer to this question will be added to our Elegant Warrior Spotify playlist. And I know you are also a music aficionado. So what is your theme song, Shanin Specter?
Well, I confess it's syrupy, but I am a big fan of As Time Goes By, the theme song from Casablanca, because it symbolizes for me the struggle that many of us have between idealism and realism, between the grounded reality of our day and our romantic dreams, between being involved and being a leader versus isolationism and passivity. And those choices that we make every day in various ways in our life, and they are very complicated decisions. So I recommend both the song As Time Goes By and the movie Casablanca.
I love it. Shanin, thank you for coming on and for sharing your brilliance with us, and have a great day.
Thank you, Heather.